I'm here with Tom Begley he's an elder law attorney in New Jersey. First of all, Tom, thanks for joining us today and taking the time to speak with me. I really
Thank you for
appreciate it.
inviting me.
And, second of all, I was hoping you could start by telling us a little bit more about yourself and about your firm and what you guys do and how it fits into what we're doing here at Elder Guide with our nursing home content.
Well, I've been practicing elder law since 1989. The National Academy of Elder Law Attorneys was founded in 1988. So the people who went to that meeting were the paradigm shifters. But I guess I was a paradigm pioneer because I jumped on pretty soon. And it's really great because you're helping people and their families, and you get a lot of self-satisfaction from doing that. Our firm, we have 4 lawyers, 16 staff people. We do elder law, estate planning, a lot of special needs trust, especially self-settled special needs trust. I've written some law books on how you do elder law and special needs, and I enjoy what we're doing.
So what you're saying is it's not your first rodeo.
No, and I think it fits into what you're doing because you're reaching out to people who are looking for nursing homes in your elder guide, and maybe in the future, people who are looking for assisted living facilities, and they're very expensive. We'll talk a little bit about how much they cost. Maybe we can do it now. In New Jersey, an assisted living facility runs probably $6,000 to $10,000 a month. A decent nursing home runs $12,000 to $14,000 a month. And I'm in the southern part of New Jersey where it's a little cheaper. Northern part of the state, maybe a little more than that. And there are only 5 ways to pay for it. The first one is called private pay. Every month you write them a check. Pretty quickly people say, ouch, doing that. The next way is long-term care insurance, but only 8% of people in the country have long-term care insurance. The next one is Medicare, but Medicare will only pay a very limited amount of home care, which is usually a couple hours a day, a couple hours a week for about 6 weeks, and then only if you're getting skilled care. And if you're getting care in a nursing home, they'll only pay if you go first to a hospital for 3 days for skilled care, then to a nursing home for skilled care, and you're making progress. Usually after 20 days, it's determined you're not making progress because in 1993, there was a miracle of modern medicine that a lot of people forget about. It was called the Balanced Budget Act. And it used to be you got 42 days of Medicare payment, but in order to balance the budget, they cut it to 20 days unless you were making significant progress. So that's the miracle of modern medicine. It may have been more driven by money than medical.
Sounds it.
The message is Medicare isn't going to pay for much. The next one is the VA. Many states have state veterans facilities. The federal government has a few federal nursing homes. There's a program called Aid and Attendance, where if you qualify, they'll pay for care at home or in assisted living, but they'll only pay anywhere from $900 to $2,200 a month, depending on whether you're a veteran with a dependent, whether you're a spouse of a veteran, whether you're a spouse of a deceased veteran, whether you're a single veteran. So it's very limited.
Right.
But the big one is Medicaid, and Medicaid pays roughly 70% of all of the long-term care bills in the country, I think. Certainly true in New Jersey.
Right. Now, long-term care can come in numerous forms. We have nursing homes, we have assisted living, home health care on a more part-time basis, adult daycare, et cetera. Some states I know have multiple programs that you have to, or different programs you apply for depending on the service that you need. How does this work in New Jersey, and sort of how do you navigate that depending on the level of care that you need?
Okay, the adult daycare that's a separate program.
Okay.
The home care, assisted living, and nursing homes all fall under managed long-term services and supports, MLTSS. So the rules for eligibility are the same. Now, people confuse institutional level of care with actually being in an institution.
Right.
But if you meet certain clinical guidelines, then even if you're receiving the care at home, it's considered to be an institutional level of care.
Okay.
So that guideline is usually the inability to perform 3 of the 6 activities of daily living, and they are bathing, dressing, feeding, transferring from bed to chair, chair to bed, toileting, and continence. So if you're unable to perform 3 of those, then you qualify for any of those 3 levels of care, even though you may be receiving the care at home. The other is if you have severe cognitive impairments, then you also would qualify for what's called an institutional level of care, even though you may be receiving the care at home.
Now let's talk a little bit more about Medicaid and the qualification process. At basic level, I know you have this income test where you have to have for 2020 anyway, $2,349 a month of income. We also have this asset test where you have to have below $2,000 in assets, and it sounds relatively simple in the big picture, but these things get pretty complicated when you actually get into running these calculations. I was hoping you could tell us a little bit more about how the income test works and how it differs depending on whether you're single or married, and then we can get into some of the planning strategies surrounding that.
Okay, so for a single individual, they can only have $2,349 income from all sources. So that would include Social Security, pension, investment income, annuity income, whatever the source, it's going to be included. For a married couple, they only include the income of the person receiving Medicaid. They don't include income of what's called community spouse. So the institutionalized spouse is the Medicaid recipient, whether they're in an institution or not. The community spouse is the spouse not receiving Medicaid. And again, it doesn't matter whether they're in an institution or not. So they disregard the income of the community spouse. Now, when it comes to assets, they combine the assets of the institutional spouse, the assets of the community spouse, they all go into one pot. So in New Jersey, the institutionalized spouse is allowed to have $2,000, and the community spouse is allowed to have half of the countable assets not to exceed $128,420, I think it is this year. $640, $128,640.
Right.
That's the maximum. So if they had $200,000 of assets, she could only keep half, which would be $100,000. If they had $400,000, she can't keep half. There's a maximum of $128,640. And all these numbers are indexed to inflation, and they change every year.
So let's say whether I'm an individual or I'm married, I have $3,000 or $4,000 a month of income, but I'm a little bit over this monthly limit. What are my options? Do I simply not qualify, or is there something I can do in that situation?
In New Jersey, you can do something called a qualified income trust. We used to call it a Miller Trust. It was based on a case of Miller versus Ibarra in Colorado. So I actually did the first one in New Jersey. The concept is you take your excess income and you assign it irrevocably to a trust. So generally, the problem is the person's receiving income from Social Security and a pension. Usually, the Social Security is under the cap, but the pension puts them over. So all you need to do is assign the pension to the qualified income trust, and then it doesn't count as income. So typically, you would have one of your children be the trustee of that trust. Every month they would get the money in, and every month they would pay the facility or the home health agency, and that solves the problem. So if you understand that, you weren't paying attention, because it doesn't really make any sense, but it works.
Right.
That's the important thing. Now, sometimes people have Social Security, which puts them over the cap. And if they have a pension under the cap, then you would assign the Social Security and keep the pension.
Oh, okay. That makes sense.
And sometimes you have Social Security but no pension, but the Social Security puts you over the cap, in which event you have to assign the Social Security to the trust.
Right. So you touched a little bit there on assets and how it works depending on whether you're single or married. But a single person has to stay under $2,000 in assets. But really, the devil's in the details there, because different assets are treated differently, and we have countable assets and non-countable assets. I want to just walk through some of the more common assets that typical people own, and just have you touch on sort of how they're treated under this asset test. The first one, the most obvious, is someone's real estate. We start with, you have personal residence. Some people might also have a vacation home or even investment property. How is real estate treated in New Jersey for these purposes?
Okay, it's the primary residence is not counted as long as either spouse is living there. So if dad is single and he's getting care at home, they're not going to count it as an asset when he applies for Medicaid. If dad is married and he's living at home with mom, they're not going to count it when they apply for Medicaid. But what they don't tell you, except in small print on the back of the application, is that when dad dies, they're going to put a lien against the home.
Right.
So you want to deal with it. So as far as the second home, the vacation home at the shore, they're going to count that from day one.
Okay.
And as far as any investment real estate, they're going to count that just as they would any other investment.
So if I have these other types of real estate, a second home, or if I don't have a spouse at home living in what was formerly my personal residence, what are some of the strategies? What are your recommendations to people? What should they do with this real estate?
Okay, so if you have a spouse living at home, one option is just deed the house to that spouse, because they don't count it as long as she's living there, and they won't count it for estate recovery purposes when the first spouse dies. Now that makes sense unless mom also has some diagnosis indicating she's going to need long-term care, or if mom is probably over age 75, then statistically there's a 70% chance she's going to need long-term care, probably beginning usually in her 80s.
Right.
So maybe that's not a good strategy. So you have to look at those things. Another strategy is to transfer the home to a grantor trust. And that way, you're going to have a transfer of asset penalty, which we'll talk about as we go along, I assume. But that would protect the home after the 5 years.
Okay.
Also, the trust can be designed so that if the home is sold during the parent's lifetime, they get the benefit of the $250,000 exclusion from capital gains tax if they're single, or the $500,000 exclusion if they're married.
Right.
Or if they don't sell it during their lifetime, the kids will get the step up in basis on death. So it's a pretty good strategy. In New Jersey, we have something called the homestead tax rebate. And if your income is below a certain level, then the state sends you a check. You can keep that if you set up the trust. We have a veterans deduction. Certain qualified veterans get $250 off their taxes every year. And you don't even have to apply for it except the first time. And they keep that if they do it in the trust. There's an exemption, total exemption for a 100% disabled veteran, and they can keep that if they transfer it to a trust. There's a tax freeze that's based on income, and they can keep that if they transfer it to the trust. So the way the transfer works is you set up the trust, it's a grantor trust, and you can retain all those benefits. The deed going into the trust says that mom and dad reserve the right to use and occupy that property for the rest of their life or lives, and they will pay all the expenses as long as they're living there. So frequently people do that when they're 75, they don't have a diagnosis, and it really doesn't affect them in any way because they're still living there, they still pay the taxes, pay all the expenses. So most of our clients come from our previous clients. So our client will send a friend in, and the friend calls to thank the client because he's going to do this trust, which makes a lot of sense. So the first client calls and says, "Why didn't you tell me to do that?" And we said, "Well, we did, and you did." And they paused and they said, "Well, I'm still living in the house, paying all the bills. What happened?"
Right.
They don't even notice that it happened. So it's an easy thing to do. And it works great. So then if mom gets sick later, it's protected for that too.
Well, that makes sense. It sounds like there's plenty of options with real estate.
So that's one. The next one is, you want to or not?
No, go ahead. Yeah.
You could transfer the house to the kids instead of a trust. The problem with that is if the kids sell the house while dad's still alive, they're going to lose that $250,000 or $500,000 exclusion from capital gains tax unless they do it in the first 2 years. And they're also going to lose the step-up in basis on death. Also, if the kid gets sued or the kid gets divorced, it could be a problem. The trust is better from those standpoints. You could transfer the home to a child under 21 or a child who's blind or disabled. And there's no Medicaid transfer of asset penalty. But you got to be careful if you transfer the home to a disabled child who's receiving SSI and not living in the house, they're going to lose their SSI.
Right, makes sense.
Or if you transfer it to a child who has liens against them, the liens are going to attach to that house. So you got to be careful when you transfer it to kids. If you have a brother or sister who has lived in the house for at least a year and has what's called an equitable interest in the house, in other words, they've been paying the bills or share of the bills, then you can transfer it to them and there is no Medicaid transfer of asset penalty. So sometimes that makes sense. If you have a child who's been providing care for 2 years, sufficient to keep the parent out of a nursing home or assisted living facility, you can transfer the child to them, and there's no transfer of asset penalty. The rules are pretty strict, and we probably don't have time to go through all of them today. They're more strict in New Jersey probably than they should be. And if somebody will sue the state, there's a pretty good chance they'll win, but people are not inclined to do that.
Cost-benefit analysis, I guess.
I'd like to do that. You could also sell your home to your child at a discount. So a home has two components. It has a life estate and a remainder interest. So let's suppose dad is single. He's 75 years old. He's going to sell his home to his child but he's going to retain the right to live in that house for the rest of his life. So the value of that life estate depends on how old Dad is. How long is he going to live? So there are tables. So under the federal table, if Dad is 75, the value of the life estate is 52%. So Dad has a $400,000 home. He could sell that home to his son for 48%
Right.
of the value of the home. So the son only has to pay like $196,000 ballpark. So he bought a house cheap, right?
Sign me up for that.
If they sell the house during Dad's lifetime, Dad's going to be entitled to whatever percentage the 52% shrunk to at the time of the sale. So we shot ourselves in the foot if we're going to do that.
Right, now we're over the asset limit again.
So it doesn't say don't do it, but with all these things, you have to think them out and what's best for Dad, which is number one. So let's talk a little bit about people's goals. Normally, the goal is best quality of care for the parent needing it. You want to protect Mom, who you want to preserve her standard of living. And if all of a sudden she's going to be living on $128,000 and she lost Dad's income, that might not be so easy to do. And then the third thing people would like to do is preserve a legacy for their kids. That's more important to the parents, I find, than it is to the kids. But it's something that it's important.
No, it is.
Kind of parse through all these things.
Yeah, and it sounds like you really need to, sounds like there's a number of factors here that probably vary from individual to individual. It depends on what kind of relationships you have with your kids and so on and so forth, and what their financial situations are.
Yeah. So there are the kinds of things that people do with their homes.
So, the next asset, probably the second most common asset that you see people owning, is some kind of retirement account. We have 401ks, IRAs. My understanding is that these assets don't receive quite as favorable of treatment in New Jersey. Could you touch on that a little bit and how these get counted and how they work?
Yes, retirement accounts are considered countable assets in New Jersey. Now that's true whether it's the Medicaid recipient's retirement account or the spouse of the Medicaid recipient. Now my office happens to be about 10 miles from Pennsylvania, where the retirement account of the community spouse is not counted. So one of the strategies people think about if the spouse has a huge retirement account is put Dad in a nursing home across the river and protect that account.
Right.
So there are other things you can do with the account too. The retirement account of the community spouse is pretty much gone unless you want to cash it in or cash part of it in and spend it or pay the tax and transfer the assets. And depending on the size of the account, that's something that needs to be considered. Now, with the retirement account of the community spouse, you can buy something called a Medicaid compliant annuity. So the rules of a Medicaid compliant annuity is you have to name the state of New Jersey as primary beneficiary on death. The payments have to be actuarially sound, which means you can't stretch them out past the death of the community spouse. So you look at the tables, what's her life expectancy, and then you have to do it at least that fast. So we usually like to do it faster. So if Mom has a 15-year life expectancy, why not do a 10-year annuity? So that way there isn't going to be anything payable to the state of New Jersey if Mom dies a little sooner than the tables say. On the other hand, you don't want to draw it out too fast because you have to pay tax as it comes out. So what's her health? What do the tables say is one thing, but what's the doctor say is something else.
Yeah. Right.
You have these rules, but you got to tailor them to the individual client. What's their situation? So there are the kinds of things that people typically do with a retirement account. Now, the other thing with retirement accounts is the beneficiary of Mom's retirement account is almost always Dad. who just went to the nursing home. So if mom dies first, we might as well change it to the nursing home.
Yeah.
But most people prefer to change it to the kids instead. But the point is, you got to change it.
Yeah, and it sounds like a recurring theme here, is you can't focus exclusively on the institutionalized spouse. You really need to be looking at this estate plan holistically as a family.
For both, yeah. Yeah.
What about life insurance? You touched a little on annuities, but with life insurance policies, there's several different kinds and fancy names for them, but they all sort of fit into these two boxes, it seems. You have those that have cash value, such as whole life insurance or universal life insurance. Then you have policies that don't have cash value, like term life insurance, which is probably becoming quite a bit more popular these days. My understanding is that these two types of insurance policies receive quite different treatment under the Medicaid asset test. Can you go into that a little bit?
Yes. Term insurance is usually something you get from work. It's almost always term insurance. Not always, but almost always. And it's cheap to buy, so people buy it. And as you get older, it gets more expensive when it comes time to renew it. But it has no cash value. So Medicaid can't make you cash it in. So if dad has a policy, usually mom's the beneficiary, and it's fine. If mom has a policy, usually dad's the beneficiary, but if she dies first, it's going to go to him. So all she needs to really do is change the beneficiary to the kids. So that's a simple thing to do. If the policy has cash value, then it's a different story. Because Medicaid says, cash that policy in, use the money from the proceeds for your care. Now, when you do that, you lose not only the cash value, but you lose the death benefit, which is always a little bit higher than the cash value. So what we suggest to people do is assign the ownership of the policy to your spouse, if that makes sense, usually doesn't, or to your kids, which usually does, or to a trust, but get rid of it.
Right.
Change the beneficiary so that it's the community spouse primary and then the kids contingent. Or if there is no community spouse, just make the kids primary. So that's pretty easy, life insurance. Now, annuities are less easy. Most annuities have deferred income, which is accrued. So that's the problem. Medicaid in New Jersey, if you have a single person, they would say cash the annuity in, pay the tax on the deferred interest, and use the money for your care. So you can kind of get around that a little bit by just drawing the money out to pay for your care, but you're going to lose the annuity, which may not be the worst thing, because if you go to a facility, most assisted living facilities in New Jersey require 2 years private pay before you can go on Medicaid. Most nursing homes vary. Some will take you Medicaid on admission, but they're not usually the best nursing homes. Some want 6 months, some want a year, some want 2 years. And if you have an annuity and you've got to use money for what I call key money to buy the key to get in, then you can take it out of the annuity and use that. The other place to get it is out of the communities or the institutionalized spouses IRA, because as you take the money out, it's taxable income, but as you pay for the facility, it's tax deductible. So, you're going to lose something, but you're not going to have to pay tax on what you lost.
Right. Silver linings.
So the other thing with an annuity is assign the ownership. So if dad has an annuity and it doesn't have too much deferred income, he could assign the ownership to mom. Mom could then annuitize it, one of those Medicaid compliant annuities that we just talked about, and basically you could protect a lot of it. Does it work every time? No. But again, it's something you want to think about. So with the annuity, again, you want to make sure that if mom has one, you got to name, if you're going to annuitize it, you got to name New Jersey as primary and the kids contingent, but you don't have dad on there.
Right.
Okay. So New Jersey's very hard on annuities. For a long, long time, they just said you couldn't do it. And then they lost a couple of court cases, and now they say you can. But they're going to be a tough sell.
Yeah.
So what?
We hit on a couple of the sort of big ticket items there, that some of the more common assets. I don't, and I know you already touched on a lot of the planning strategies that you like to implement. I'm just wondering if there's any others. Someone comes in, they've got excess income or assets, and depending on how much time they have before they're going to need long-term care, what are some other strategies that you like to spend those assets down in order to sort of accelerate that qualification?
We always tell people there are two ways to get rid of money. One is to spend it, but only on things that make sense. And the other is to give it away, but you're going to have a penalty. Now, a lot of people think, well, let's talk about spend down first. So if dad is going to require some form of long-term care, and mom is only going to be limited to $128,000, we don't want her to have bills coming up. So we try to look ahead. What's mom going to have to spend money on over the next 5 years that we could spend it on now out of the money we were going to give the facility? So one would be a car. Mom's driving around with a 10-year-old car. Maybe it's time to buy a new one, so she doesn't have to buy it out of her $128,000 when this one dies in the driveway.
Right.
Now, so we do that, and then we look at the house. Are there any things that need to be done by way of home improvements over the next 5 years that we could do now? Does it need a new roof? Does it need siding? Does it need exterior paint? All of those things. And then we look at the inside of the house. Does it need appliances? Does she need a computer? Does she need a new iPhone? Maybe she has some of these things, but they're on their last legs. So if you've got a real old computer, maybe think about getting a new one. You need new carpet, flooring, all that stuff. So we want to have no expenses over the next 5 years. What about debt? Do you have money that you owe for a mortgage, a home equity loan, credit card bills, loan sharks, gambling debts, drug deals gone bad? Settle all that stuff up now so you don't have to deal with it out of the $128,000.
Be proactive.
Buying a funeral is something. Do you have plots? Are you going to need plots? Do you want to be buried? Do you want to be cremated? Do you want one of each? What's it going to cost? You don't have to spend that money now. You don't have to spend it until you're going to apply for Medicaid, but at least get some idea what it's going to cost and set it aside. And if you want to spend it now, you can do that. If you have an IRA, you want to convert it to a Roth IRA. Pay some tax now and don't have to worry about that later. By the way, if you have an IRA under the Secure Act, they just changed huge tax increase on that. So maybe you want to think about leaving it to a trust for a child with disabilities because they're not subject to the Secure Act. So think about that as a part of this planning. If you have kids who are taking care of you, you could pay them to do that. You have to have a written agreement. You have to spell out in great detail what care they're providing, and you could probably pay $15 an hour and get away with that, but they have to really be doing something. But a lot of these kids are providing care for free, and this is a way to get assets transferred from the person who needs Medicaid to the child without a Medicaid penalty. Now, there is going to be income tax for the child receiving the care, but sometimes it's cheaper to pay the tax than it is to pay for the facility. So something to think about. If you have a spouse who's terminally ill, what we frequently see is you have two sick spouses propping one another up. And now dad's getting to the point where he's going to need to go to a nursing home, but mom's not going to live very long. Transfer all the assets to mom, and she dies. She has to leave him a third. but she leaves the other 2/3 to the kids, no transfer of asset penalty. So we save 2/3 just from doing that. So they're the things that we use the most. There are a lot of others, but I don't think we want to go through all of them, right?
No, it's fine. It sounds like you have plenty of tricks up your sleeve. I think that list was sufficient.
So these things are complicated. And I always tell our clients, if you don't have a headache by the time this meeting is over, I haven't done my job thoroughly.
Or they weren't listening.
We always stay with people. We give them a written plan. They get in about a week. And then we schedule a follow-up in about 3 months after they sign everything to make sure that everything that should be done is being done. And then we have another one like in 11 months to make sure, again, that stuff that's supposed to be done is done. Because a lot of people say, yeah, I'm going to do this, but they're afraid of giving up control. They're really reluctant to do that, or they didn't understand something. So, you can't have stuff falling between the cracks if 5 years from now they're going to be spending $15,000 a month on a nursing home because you didn't understand something.
Yeah, the execution of the plan sounds like it's just as important as the drafting of these documents.
Oh, absolutely, yeah. And the other thing is customer service. About 25 years ago, we had the Ritz-Carlton Hotel train us on how to do customer service. So,
really?
Yeah.
That's cool.
And we've stayed at the Ritz-Carlton Hotel in Sarasota. The service is very good.
It's a beautiful hotel.
And we did it because we were selfish. We thought if we could give the customer service they do, we'd get more referrals from our clients. And it worked.
Yeah.
There's another byproduct, and that is it's a nice place to work now here because people don't call and complain.
Right.
Meet their needs.
It's great that doing the right thing is so good for business. We covered a ton of planning. And, it seems to me that there's really two aspects of planning. One is what we've hit on the most is obviously qualifying for Medicaid to begin with, getting them to pay the bill. But then there's this intersection between Medicaid planning and, what I would call estate recovery planning. And estate recovery is this process where, if you go into the nursing home and Medicaid pays for it, and then you pass away, they're still going to, they're going to want to be reimbursed for their expenses. Medicaid's going to want to be reimbursed, and they're going to go after your assets after you pass away. How does that work in New Jersey? And what, if anything, can you do to ensure that your plan not only gets you into the nursing home, but, preserves as much of your assets as possible for your next generation?
Okay, that's a great question. Under federal law, states have to recover from the estate of a deceased Medicaid recipient for any money they've spent on that person after age 55. But the federal law gives an option. The state could also extend it to what's called non-probate assets. So New Jersey, unfortunately, elected to do that. So if dad is single and he dies and he owns a house, that's part of his probate estate, and New Jersey will put a lien on it when he dies. If he owns the house with mom, they will defer collecting on the lien as long as she's living in the house. Or if he has a child under 21, they'll defer until the child is 21, which very seldom happens. Or if he has a blind or disabled child, they'll defer until that person leaves. And then they don't have to, but in New Jersey, they will also defer if there's a family member who's been living there. Even though they're not disabled, they'll defer until the house is sold or until that person dies. So you want to be very careful when you do your Medicaid planning. So when we talked about the house,
yep,
you want to get the house out of dad's name into mom's name because they'll recover against dad. It won't affect Medicaid eligibility, so we can get on Medicaid, but when he dies, they're going to put a lien on it. But
right.
if it's mom's name, they can't. So you always want to do your planning with an eye toward how is this going to affect future estate recovery.
Right. So sort of the last thing that I always think of with this subject is, you hear about you hear about a lot of misinformation, a lot of bad planning and strategies. A lot of that focuses around two things, in my view. One is people who are trying to be sneaky, or they're doing things that aren't allowed, or and not disclosing it to Medicaid. And then the other scenario is people that are just making gifts, and they're not focusing on the look back rule. And I believe in New Jersey, so you touched on this, it's a 5-year look back, where they're going to look at gifts you made within 5 years of going into a nursing home. What advice do you have, for people that are trying to do this themselves, and just sort of either failing to make disclosures of everything they've done, or just sort of gifting without a plan, without consulting with an expert? What advice do you have for those people?
Okay, well, we see that two ways. We see people who tried to do it themselves, had problems, and then they come here. And then the other one we see is people come here and they want to save the money, so they take what we told them and then they try to do it themselves. But it really is complicated. And if you save 1 month of a nursing home, you're going to save more than what you paid to do that. So it almost always pays to have somebody help you with it, because it's very, very complicated. It really is. A lot of lawyers screw it up.
Yeah, it's true too.
And they've been doing it for a while.
It sounds like a service that ought to sell itself.
Right. Get somebody who's done it before.
Yeah, and having had this conversation with you, I couldn't think of anybody better than you to provide that service to a client. You just have a wealth of information, Tom. And again, I really appreciate you taking the time to speak with me today.